Okay, hello everyone. So again we are here with the question number 4 of paper 1, right? So half of paper 1 is almost complete, right? After today's lecture, now I will try to complete whole paper 1 in the coming weeks. Now what is the question number 4? Now question number 4, if you will see, it have 4 sub parts. It means it consists of 4 questions. Okay, so question number 4a, this is 10 and 10 marks each, right? This is 15 marker and this is 15 marker, right? The latest UPSC you might have seen. Now let us read one by one question and try to understand that how you can approach their answers. Okay, now if you'll see question number 4a1, it says that do local bodies enjoys autonomy in the performing their role in the field of economic development and social justice? Explain in the light of relevant constitutional provision. Now see, again it is a very generic type of question, right? Now this question is basically a GS paper 2 question, right? But as it is given in law optional, right? So the answer has to be little bit some legal provision has to be cited by writing your answers, right? Now how do you approach it, right? Now the demand of the question is that you have to write that how local bodies have been enough empowered within the scope of the constitution so that they can play an important role in economic development. Right. So what do you mean by local bodies? So basically municipalities and panchayat, right? Now in the case of economic development, you must have seen that the provision related to panchayati raj institutions that talks about gram sabha, right, or that talks about gram panchayat, right, or jila panchayat, at the topmost body in that layer, right? So how they advise, right? One layer advises other layer in terms of planning economic activities of that particular locality. Okay, now the constitution provides for the same, right? So the constitution provides a mechanism in which that advice could be there, right? Like for example gram sabha, right? So they can give advice and finally a law can be made in according to that advice. Okay, similarly in the case of municipality, the same thing happens, right? Mayor receives our advice from multiple municipal committees, right? Municipal committees on suppose sanitation, municipal committees on housing, right? And ultimately mayor comes up with certain rules and regulations. Okay, so it means that our local bodies do enjoy a certain autonomy, right? But you have to cite constitutional provision for those autonomy. Okay, so that is the demand of the question, right? So how will you approach it? Talk about local bodies in general, types of local bodies, what was the objective, right? Now initially you must have seen that the local bodies did not find its place in the constitution. It was through the amendment, right, 72-73 amendment, that these local bodies became permanent part of the constitution. Okay, now this local body is very unique in the sense that you must have seen that Gandhi was a very huge supporter of this panchayati raj system, right? And he did not wanted a parliament in the British monarchy style, right? But they wanted a parliament sort of a the panchayat will elect a jila panchayat will elect a state panchayat, and the state panchayat will elect a national panchayat. Right, so he was in supporter of that, not the Westminster model of democracy, right? But obviously, that did not happen. Okay, then we will talk about the body, power and function, autonomy. Right now, in the case of autonomy, you will write certain negative points also, that how this autonomy is sometimes overridden by the states. Right, so if you look at the constitution, you will find, right, that after giving the power to the panchayati raj and the municipality, the constitution have a specific articles that all these powers are subject to the law made by legislature. Right, so what is the meaning of giving the power if you are making it subordinate to the state legislature? Okay, so that is a very fair criticism that you can give. Now again it is a 10 marker question. Now I mean how much will you write is important here. Okay, done, right? So I have given here also, you can talk about, it's very detailed, it is given, you can pick and choose few. Okay, now let us talk about describe the power and function of Union Public Service Commission. Now you have to cite simply articles, okay, these are the powers and functions, right? You cannot separate power and function, right? So there is no specific power which is not also a function. Okay, so you write both of them same, but if you want you can write it separately, but it will be sort of a repeated one. Brief introduction of UPSC, how it provides for establishment of a UPSC and how it UPSC will act as a overall agency for the recruitment of the services under the union, etc. And then constitution provision with regard to power and function, right? You need not to separate it, you can write it together itself, because it is again a 10 marker question. If you separate it, it will take a lot of time. Now there is certain distinction between power and function, but as far as the constitution provision is present, this is, I mean, there is no such difference. Okay, I mean, what is the power is also the function. Okay. Now here, however, I have separated it, but you might write same, right? Like for an example, functions to administer examination, etc., etc. With regard to power, to make rules, that can be said to be a power, but that is also a function, right? This will be consulted, right, with regard to this, but those all are, that is why I'm saying that is not a power, because that is not mandatory, right? To dismiss a civil servant, UPSC's consult is not a mandatory thing, so they might not consult also. Okay, so that is why when you say power, it means it is a very something which cannot be waived, right? But here it can be waived, right? So how can that be a power? But still, you can write it separately as a power. That's all right. Okay. Then let us come to question number 4b, right? That talks about parliamentary privilege, right? Always there is a question with regard to parliamentary privilege. Each exam, right? Like in the test series, I gave a very interesting question. It have been a bone of contention, right? The same question was asked in 2019, right? So there, right now it is, the rationale behind legislative privilege, that why the legislative privilege should be given, right? So there are two rationale basically, right? One is it is a democracy, right? And in a democracy, free debate can only be possible if the threat of prosecution do not hang over the elected legislative, right? And second is, if the legislature wants to command obedience, right? So there has to be, it has to be seen as an honorable institution, right? So there has to be, contempt power to punish someone who dishonors them. Okay, now that is a very generic thing to say, but still that is one of the cause, right? So that is what is written here. The parliamentary privilege is an essential incident to high and multifarious functions. Multifarious means democratic, high means it is considered a good function, or high in the sense that out of all function, making law is one of the very good functions. Same argument applies in the judiciary as well, right? Why do we have contempt power of judiciary? So that its majesty could be saved, right? Or majesty could be maintained. Okay. Now the disrespect can either come from the person's behavior, or it can either come from the threat of violence. Okay, so if I want to command the respect, one way is to I do good things so that you will respect me, right? And the second thing is that if I have a threat of violence, which do you think is a much better thing to do let me know which is the most effective way of commanding this respect. Now the court have both, right? The same thing applies here also. In the case of legislature, they have contempt power, right? So that is basically the power of sword. Okay, but whether they should use it or not, that is a separate issue. Now you write general introduction, and you can write the provided the whole privileges that is provided under the constitution, right? And then like individual privilege, collective privilege, right? So you may write one or two of them. I have given all of it, but you can write one and two, more than sufficient, right? And then you write, this is the main point, that is your rationale behind the privilege, why this privilege have been given. Okay, so the rationale I have already given you: important function, democratic institution, right? Which broadly fits into three main areas, this. Okay, so that can only be done if they are this privilege is attached to them, that they will be not harmed if they perform that function. Okay, so that is the main cause, right? So you can talk about suggest some reform, although not asked. You can in conclusion generally write, okay, certain reforms can be given, right? Or reform is asked. Reform is specifically asked. Okay, so you have to write reforms very specifically. If not asked, still you can write, but write in a very generic sense. But it is here specifically asked, right? So you write the first reform that is needed is the codification. If you read the privilege part of the constitution, it says subject to the constitution and the rules made on that behalf by parliament. These are the privilege, right? It means it is not codified, right? Not codified. Okay, so it needs to be codified. Okay, that is the first thing. And then you write very generically that you have to reiterate the same thing in a different wording, that yes, parliamentary privilege is essential to functioning of a healthy democracy. Okay, that's it. So it is a 15 marker question, 250 words. Now C question number 4C, it is a little bit more philosophical in nature. While certainty of law is important in India, it can't be at the cost of justice. Critically examine this statement in context of curative petition in India, refer to relevant case law. Now what is curative petition? See, we have a doctrine of res judicata, that if something, and stare decisis as well, if something have been decided, it need not to come before the court again and again. Right? So that the public policy is that there has to be a certainty of law, that something have been decided, it has to be followed. That's it. You cannot be allowed to come again and again before the court. But our Supreme Court, our Constitution provides that the Supreme Court, there are two layers, right? Once the decision is reached, you can ask for, a revision of that decision, right? And after that, if the revision is dismissed, nothing can be done, right? Now, in the Rupa Ashok Hurra case, right, the Supreme Court sort of, did a, what we can say that, it was a sort of a penance, or it is a recognition of that human infallibility. Fallibility, not infallibility, that human beings are prone to commit mistakes. Okay, the human being cannot be said to be perfect, right, and they are prone to commit mistakes, right. So in order to look at it at last time, extra constitutional remedy was created, right, in recognition of that fallibility, that is your curative petition, right. So that is the philosophical point that you will write, that why curative petition, right. So the main philosophical point is this itself, that human fallibility has to be recognized. Then you will go and write about the case law which originated it, the Rupa Hurra Ashok Hurra. Now in that you will say that there are certain limitations that was imposed on the curative petition itself, right. Now what are the limitations that we have? The limitations are basically procedural in nature, that a senior advocate must certify it, okay, before moving it, and it must be moved before the senior judges of the Supreme Court in chambers before going to an open hearing. Right, so if they want to dismiss it, they can dismiss it. Right now, in curative petition, you write, the ground on which it can be filed. Right now, there is a very unique point here that I don't think it have been mentioned here. Right, that is with regard to Article 12 and curative petition. Right, Article 12 says, Article 12. Yes, it says that the word state do not include judiciary. Right, so it means the judicial order cannot be challenged on the ground that it violates fundamental right. But the curative petition says that no, the judicial order, that is your Supreme Court judgment, can be challenged on the ground that it violates principle of natural justice. Right, so it is sort of saying that judicial order or the judiciary is also a state. Right, so that is the penance that I was talking about. The Supreme Court is not very clear about whether the judiciary is a state or not, right? But curative petition sort of gives them recognition of a state. Their judgment also can be wrong or can be violative of principle of natural justice. Getting my point? Okay, so that connection also, if you want, you may write it down. Okay, so that is a very important connection, right? Now this importance, philosophical lines. So I have given here certain philosophical lines, right? You can write here. Miscarriage of justice and prevent the abuse of the process, right? Lapse in the judicial system, final option of grievances, right? So all the philosophical points and that is written. If you can write 3-4 points, that will be more than sufficient. Okay. Now again, if you have any question, you can comment, right? And you can, and I will try to answer it. Done. So that ends our, paper 1, part A, that is related to Constitution and Administrative Law. Right, from next class I will start with paper 1, part B. Right, part B again have question number 4 to question number 8. That also I will cover. Okay, so hopefully in coming weeks we will cover the whole paper to 2020 of paper 1, that is your Constitution and International, and paper 2 also related to tort or other subjects. Okay, done. Chaliye. So that will be all. Thank you.